All right, so welcome everybody to the Senior Concerns Seminar Series. I'm very happy to have our Legal and Financial Planning for Alzheimer's Disease program today. Our speaker is Christopher Young. He's an attorney with the Alvarez Law Firm. He is certified as a specialist in estate planning, trust, and probate law by the State Bar of California Board of Legal Specialization. Mr. Young's practice is focused on elder law, estate planning, probate, and trust administration. So we thank you so much for being with us today, and I'll turn it over to you.
Well, thank you very much, Martha. So I'm going to share my screen, and hopefully this comes up. Are you able to see that?
Yes, we can see that.
Great. Okay. So as you can see, the logo at the top right, this is I think a co-sponsored, or at least there's an involvement from the Alzheimer's Association, our local chapter. And I think some of the members are on this webinar as well. So hello to them. And I looked at the list, and Martha, I noticed a lot of names I recognize too. So a lot of your coworkers, and so hello to the Senior Concerns staff and supporters. Thank you very much for having me. This organization, both organizations, but Senior Concerns and the Alzheimer's Association are near and dear to me and do such wonderful work. And I'm just happy that people could be part of this webinar and hopefully able to learn something or come away with something new that they didn't know already. So the topic is legal and financial planning for Alzheimer's disease. But I will say that although there's specific information related to Alzheimer's disease, much of the information that we'll cover today is universal. It's important for everyone, every adult, to be thinking about these issues. And primarily for the reason that we simply don't know what the future holds. And it may be something like Alzheimer's disease, or it may be something completely different. But to be prepared and to think ahead is really important. So sometimes at the end of the presentation, people ask, now, who are you again? Martha did a great job introducing me, but just a little bit about me and my background that may be helpful to you. As Martha said, I am a certified specialist by the State Bar in this area of law. I've been playing this since I was 4. That's a violin, and if you have a beer in your other hand, it's a fiddle. I'm originally from the City of Roses, Portland. But because of that beautiful lady, my wife, Sarah, who's from this area, we moved down here in 2012. And those are the 5 kiddos. Oh, we'll come back to that one in a minute. So back to the legal and financial planning, and we'll go back and forth a little bit. One thing about these slides to know is that they are prepared by the Alzheimer's Association, and they are national. So there are some terms that we'll talk about as they come up that may not apply as specifically in California, and that's okay. We'll touch on those, but they are very helpful slides, and so we will use those today. So our learning objectives today are to understand the importance, as we touched on, of advanced planning, of getting our planning done as early as possible, and avoid the possibility, which we do see from time to time, that it becomes too late. The earlier that we can start planning for our legal and our financial needs, not just what happens when we die, but what happens, and this is something that elder law is very focused on, and as an elder law attorney, I'm very focused on, what happens if we become incapacitated during our lives and need the assistance of another person to help us. So we care about who gets what when we pass, but we care even more about making sure that we and our needs are squared away during our own period of convalescence, whatever that may be. So, and becoming familiar with the specific legal issues and future care options and financial issues pertaining to dementia. We'll touch on those a little bit, but frankly, in the time we have, we're gonna focus more on the legal, financial, and important steps that we can do to prepare and avoid nasty surprises because we didn't have documents in place. So we'll talk about the primary documents and how we can put those in place. And first thing we want to do is hear from John. John is an Alzheimer's patient. He has what's called younger onset, or used to be called early onset Alzheimer's. And he addresses, I think very compellingly, why it's important to get an early start. So here's John.
Knowing that you have the disease in early stage, first stage or whatever, allows you to go through the financial planning and the estate planning functions that most of us my age are procrastinating about. It was very important to go through that cycle and decide who can answer for you from health and from financial matters, and to get all that resolved up front. Don't wait, get it done now. If you wait, you won't be able to fully articulate what you want done.
All right. So hearing from John, I mean, he speaks a universal truth, but especially important for those who have had a diagnosis. What's interesting is, there's 3 bullet points on this slide about what the advantages are for planning early. It allows for informed planning of complex issues, and that's really important because as we go, our capacity can decline. It may not be sudden, it may be over time, but we may not be able to address more complex issues that we could earlier on. And it allows people who have dementia self-determination and choice regarding these issues, and allows them to be as involved as possible. And as I alluded to earlier, it avoids the difficult consequences of waiting too long. And we'll talk very briefly about what some of those consequences are. Now, well, let's talk about the legal issues. The goals of the legal planning slides and the legal planning part of this presentation are to allow us to learn about how to make plans for healthcare and long-term care, and to plan for our finances and our property. And one of the most important things we can do when we are planning is to appoint somebody that we trust, somebody to make those decisions for us when we're no longer able to do so. So that's a primary goal of legal planning. And the first document that I want to touch on is the Advanced Directive. Advanced directives, sometimes you see those with a D at the end, but really the technical term is just advanced, because you're telling someone in advance what it is that you want done regarding your health care, decisions having to do with your treatment, your care, and your end of life. All right. So these used to, in California, be divided into 2 separate documents. You'll see those documents listed at the bottom. There was a durable power of attorney for healthcare, and there was a living will. But because of confusion that came from both of those very poorly named documents, first of all, there was confusion with a financial power of attorney, and then there was also confusion with a last will and testament, which is not a living will. These documents were combined and made into an advanced directive. So what you would get today, and they are freely available online, although there are some reasons why you may not want to use a free form, and we can talk about those, but is to combine these 2 documents into a single advanced directive, to name who's going to make decisions for us, and to give instructions, directives to our agent and to our medical provider as to what we do and do not want done when that time comes. Let's step back and talk a little bit about legal capacity. When people have a diagnosis of Alzheimer's dementia or something else along the same lines, often they think that that's it. They don't have the ability. A diagnosis is it, and we cannot do anything legally anymore. And that's just simply not true. In California, we have probate code sections 810 through 812. And if you're really having insomnia tonight, go ahead and look those up online, and you can read what I'm referring to, but I'll summarize them for you. Probate code 810 says that we start with the presumption that each one of us has the ability to make a decision, to make a legal decision. That's the presumption. But there's an extra word in there called rebuttable. So the presumption is rebuttable, meaning that if in fact we don't have that capacity, well, then a judge may find that we can't make those decisions. But we start from the basis that everybody can make a decision. And then we look at probate code sections 811 and 812 for some more specifics about what goes into a decision as to whether somebody can make legal decisions. And essentially, and probate code 812 is very helpful, especially to us attorneys. We look to whether people can appreciate and understand the consequences of what their decision will have on other people, on themselves. That's very much the heart of probate code 812. So that is not something that just simply goes away when we get a diagnosis. I'm going to speak frankly here. There are people walking around today who have no diagnosis, who probably have no business signing legal documents. And conversely, there are people who have an early diagnosis who are fine signing legal documents and should get into an attorney as soon as possible to do that. So don't think of a diagnosis as like a light switch where you just go to off. It's not like that. But we do want to act quickly, and that's what the point of that video was, to do things as quickly as we can and to avoid nasty surprises later on because we couldn't do that, because we couldn't sign legal documents. So we've talked briefly about advanced directives for healthcare. The other type of power of attorney that's very common, and you may very well have one already, is called the durable power of attorney for finances. All right, so you'll see there listed about 2/3 of the way down, durable power of attorney for healthcare. Remember that went away in California, and now we have the advanced directive that becomes part of that. But then there's the durable power of attorney for finances and property. And that is a power of attorney that we still have, and every adult, frankly, should have one of those, because it addresses who will make decisions for us financially if we're not able to. It also helps us say, you know what, I think that I might be prone to scams, or gullible in my elder years, and I don't want to have somebody take advantage of me. So I want to have this friend, this child, this trusted relative, somebody like that, to make those decisions for me. So that's done through a durable power of attorney for finances. These are lasting. That's what the word durable means in the legal context. It means that it lasts even if you no longer have capacity. And that's very important. So if you have a power of attorney for finances, check to make sure that it says that it's durable. It needs to have that word. And it needs to be created in accordance with state law. There are many powers of attorney out there. And this is where I did want to talk about, you saw that briefly a second ago, the penknife, or the Swiss Army knife. This is the power of attorney that I most often see that comes into my office. And there's nothing inherently wrong with it. It is usually what's called the state statutory form power of attorney. So if you've seen a power of attorney that looks like this, it says who is appointed and what their name is, what your name is, and then you have the ability to initial next to certain powers that you want to give your agent, or you can just initial next to letter N at the bottom and give them everything. That is the state statutory power of attorney. It comes into effect immediately, and it doesn't include everything that you might want to have in a power of attorney. So it's there, it's freely available, and it's better than having nothing at all. But if you go to an elder law attorney, you're most likely going to end up with a power of attorney that looks more like this. And you may never need that wine opener or that toothpick, but by golly, if you do, you're glad you have it. So that's the way we take a multi-tool approach to a power of attorney to discuss some of the additional powers you might want to give your agent. Some of you might be thinking, what's an example of one? You cannot, with a state statutory form, amend the trust or the estate plan of somebody that needs your assistance. It's just not a power that's built into that state statutory form. But you can give that power through a customized power of attorney. And why might that be important? And this really happens most often with spouses. What if one spouse begins to lose capacity, and then something is known about a child? Maybe they develop their own disability, and you might want to make some changes to the estate plan so that they don't lose their public benefits when you pass away. And that would be using something called a special needs trust. So what if we want to do that? But if we've lost capacity, if one spouse has lost capacity and doesn't have a power of attorney that would allow for that, then you run the risk of not being able to amend the estate plan, or you have to go to court to get it done. All of those things are very expensive. Whereas if you just spend a little bit of money with an attorney and get a power of attorney that looks more like this, the multi-tool approach, you have a much better chance of being able to accomplish what it is that you want with regard to the power of attorney. So go back to the slide. So this is a video that addresses not only the creation and early planning, but also the updating of your legal documents. This is Eve, who cares for her husband with dementia.
we had done a number of things, probably 20 years ago, having a trust, filling out wills, having powers of attorney, those kinds of things that one sort of does. And that was sort of another shock to me. I came here and I thought, we don't have an attorney here. I've got all this stuff, it's under Ohio law, and all these things are different if you're in a different state. So I found myself a wonderful elder law attorney. And one of the first things she said to me is, and I told her that I wanted to be my husband's power of attorney, which I am now. And that was an easy thing to do. But then she said to me, who is your power of attorney? And I said, well, my husband, because you're in denial through all of this, even though you think you're with it, you're still in denial. And she said, he can't be your power of attorney.
All right, so that is a very, very common situation. We attorneys refer to those as I love you estate plans. And it's because oftentimes our clients look at each other and say, I love you as they sign these, which like the video said, they name each other as their agents. There's nothing wrong with that when everything is early on, but the most important thing you can do is to name backups. So another concern I have with the state statutory form is it's not very intuitive, and it doesn't really lend itself to naming backups. You'll see some variations on the form that do, but the state statutory form does not really lend itself to naming backups. And it's really vital to have what we call a deep bench, something, a lot of people named. It doesn't have to be a whole baseball team. You don't have to have 9, but name at least three, if not 4 or more agents, because we don't know what the future holds. And it's really important to have security of knowing that when the time comes, there will be somebody that you trust there able to help you. This slide has to do with the living will, and we've already talked about what happened to that in California. It is the person's choices for future medical decisions, such as artificial life support. And it is now in California incorporated into the advanced directive. So we don't need to use that term. And if you find somebody that says they have a living will, you'll do them a favor if you ask, are you sure? Is it an advanced directive? And if they say, no, it's a living will, I did it 20 years ago, you might suggest that they take a look at that document and make sure it says what they want. First of all, our ideas and our preferences change in 20 years. And second of all, it may not have everything they need in there. So again, there's no harm in updating things and making sure that your documents that might have been created some time ago are still up to date and reflect what your wishes are. Let's talk about the other kind of will, the will that we all think of, and that is the will that names executors or beneficiaries of our estate, and it takes effect when we die. Often that's referred to as a last will or testament. And this is the only slide that addresses this. So I'm going to cover a few things while we're talking. In California, a will is treated like a letter to a judge. And it says, dear judge, when I die, please do these things with my property. And please have this person that I've named do them. The problem is it requires a judge. A will, unless you have, and I'll give you the exact number, $166,250 max. When you add everything together other than your car, you put that all together. If you're under that number, including real estate, then you may not actually have to go to court. There may be an easier, simpler way of doing it. And that's something that I could certainly talk to you about offline if you have questions about it. But most people, especially if you own a home in Southern California, you're going to be well over that number, because they don't care about the equity that you have in your home. They care about what is its retail value. What is it worth? If you sold it tomorrow, what would you ask for it? So unless you have a very small property, perhaps in Northern California, you're going to be well over that $166,250. So treat it as a letter to a judge and assume that if you have a will, unless you are well under the $166,250, you are going to go to court, or your heirs are going to have to go to court to administer your estate. People may not like that and like that idea. And I've practiced in 3 states, Oregon and Michigan as well. And California is definitely where probate, that's the process of administering a will. Probate gets the bad name because of the time involved and the costs involved. And let me just touch a little bit on what the cost is so you can get a sense for it. Well, hang on, there we go. These slides are in a little bit different order. So if you have a $400,000 estate, remember this includes the gross value of your estate, including the gross value of your real estate. So for many of us, that's already, we've reached that number in Southern California. The attorney fees would be $11,000. The personal representative, that's your executor or your administrator of your estate, they get $11,000. The total fees would be $22,000. You may say, well, my executor wouldn't take a fee. I often hear that at the beginning of a probate, and by the end of it, when they see how much work is involved, they've changed their minds. So I wouldn't count on that, but that's often the case. Now, for most people, their numbers are going to look more like the second or third number, 800 or a million. Remember, gross value of your real estate. So for a lot of us, we're in that boat. $19,000 attorney fee, $19,000 personal representative, and now we're at $38,000. If it's a million, we're at $46,000. So you get the idea. Then the court gets you coming and going. To file the petition to probate an estate, it's $465. To file the petition to close the estate, it's $465. There's something called a probate referee. The court wants to use its own person to appraise all of your property, to find out what the actual gross values are. So their own, you get to appraise cash, and that's it. Everything else is appraised by a professional appointed by the court. They get a piece of the pie. So you start to see what the costs involved in a probate are in California. And then there's the time. And I won't get into great detail, but I will say that it's the very rare probate, and usually probate without real estate involved, that closes in less than a year. Most often it's 1 to 2 years. And that's just because of certain timelines that are built into the probate code, time for creditors to make claims, et cetera. And just frankly, the time involved in getting in front of a judge. The courts are very busy. Here in Ventura County, it's less time. In LA County or Orange County, it may take 6 to 9 months just to get in front of the judge. So you get an idea for why, probate is something that people try to avoid. And that brings us to the next slide, and that is living trusts. So something that Martha knows that I speak a lot about, and she's heard me speak about it before, is living trusts and how we can avoid that probate problem. And if you have one, congratulations. If you don't, and you have an estate that exceeds 166,250, you might want to consider it. There are other benefits to trusts, and we'll talk about them, but the basics are that they name a trustee. Think of it as a company. When you set up a trust, you're setting up a company. That it consists, the assets of that company are your assets. And the trustee is the manager that you've hired. Most often when we start a trust, when we establish a trust, we are the manager. We are the trustee because we're up to the task, no problem. But at some point, either at our death or at our incapacity, we have to have a trusted person named who will make those decisions for us and manage our assets for us, to run our company. That doesn't mean that we don't own the trust. We still own it. We'll always be the owner. The terms you hear most often are settlor or grantor. Sometimes I hear creator. That's a little presumptuous, but whatever those terms are, if it ends in an OR, most often those are that's the term used for the person that has set up the trust. The trustee is the manager, and the property is your property that's going into the trust. All right. It also provides instructions on how to manage the estate and any rules that you want to set up. And this certainly comes in handy after you're gone. If you have children or grandchildren that are maybe not very good with money, you can be very specific. I'll give you a couple of examples. I've created trusts where the child or the grandchild had to submit to a drug test before they were able to get anything out of any kind of cash out of the trust, because the parent or grandparent did not want to harm their child by giving them cash, which could then cause them to become even more dependent. Another, if they have a hard time getting off the couch, you can set up something that's earn a dollar, get a dollar. So you can say, well, when show the trustee your W-2 and we'll match it. And these are just some ideas that people have done over the years. And another big one is adding the number of years that it will. So if you just have a will and you have a child who's over 18, they're going to get the money at 18. If they're under 18, that's even worse. And if you pass away and you have minor children, then we're looking at a guardianship where somebody has to be appointed by the court to manage anything over $5,000. But if you have a child and they're 19 and they pass away, or a grandchild, if your child has passed away and now there's a grandchild who's 19, they're going to get a big check, and they may not be old enough to manage that money on their own. And so another benefit of trust planning is that you can say that child or grandchild needs to be 25, 30, 35. There are people who have come back to me every 5 years and bump it up because, maybe we want to have them a little bit older, and that's okay. So you can have that level of creativity and that level of control in a trust. It can include a broad range of property. I'll just mention one thing here. A lot of people have vacation homes in other states. Believe it or not, we talked about probate, but if the probate court only has jurisdiction over property here in California, if you have a condo in Arizona or Hawaii or something like that, you're going to have another probate there. We call that an ancillary probate, but it's still a big hassle. If you have a trust, you can put all of those properties in a single trust here in California and deed them to the trust and avoid all of that. So you can actually avoid multiple probates, not just one. So that addresses the next point. And again, you can specify whether a trust will end when the last beneficiary dies or continue to benefit others. That's just one of the many things you can do. You can say that somebody gets income for their life and then they goes to your grandkids after your child passes away. That's just one thing. So we can talk in the Q&A if there's people have specific questions about trusts. And Martha, if there are any questions right now, please feel free to interrupt me on trust, because I'm happy to address those while we're doing that here. Otherwise, just know that when somebody has a diagnosis of dementia, Alzheimer's dementia, or any other kind of dementia, it's important to have a good team involved who can, of legal team, financial team, and other types of fiduciaries. And fiduciary is a technical term that says basically somebody who has a duty to provide for your needs, to care for you, to look out for you, and put you before their own interests. All right. And to involve family to the extent you can, and to have as much communication between everyone as possible. This will help, and again, to avoid surprises, problems down the road. And if things are too late and there hasn't been planning done, there is an option where we can go to court and obtain what's called conservatorship. You'll see in the lower right here the word guardianship. In California, the term is conservatorship. Conservatorship of the person has to do with making sure that someone's healthcare decisions are made, that their living arrangements are made, and that their educational needs are met. All of those things are covered under what's called conservatorship of the person. In other states, you'll see that as guardianship, but here in California, conservator of the person. There is another type of conservator, and that's conservator of the estate. And that, as you might imagine, is somebody who manages the financial side of things. Remember, this comes in if no planning was done, or if the planning hasn't worked for some reason. So let's talk a little bit about, again, this is guardianship on the slide, but we call it conservatorship in California. So a diagnosis of dementia, this is an important point. A diagnosis of dementia alone is not sufficient to obtain conservatorship of the person. keep in mind what we said earlier, which is that we want to make sure that you have the ability and the autonomy to make decisions as long as possible. And just having a diagnosis does not meet the requirements of Probate Code 810 to 812. You also have to have an actual loss of capacity, not being able to make the decisions on your own, in which case a court would, if necessary, if no other option existed, appoint a conservator. There have been times when I've been appointed by the court to look into things for somebody whose spouse, for instance, has petitioned the court, maybe not for conservatorship, but for other types of things where they need access to money. Let me give you an example, and this goes back to the power of attorney and why it's so important. I was involved in a case where an elderly couple here in Ventura County, the wife was in a board and care. She had advanced dementia, and the husband had been paying for it every month on a credit card. And eventually he was unable to do that anymore, and he couldn't get access to her retirement accounts, his wife's retirement accounts, even though those were what's called community property. And what that means is he had certain rights to those retirement accounts because he was married to his wife when those accounts were built up. But his name wasn't on them, and there was no power of attorney. He had to file a petition with the court, asking the court to allow him to access those funds. So this is one of the things you can do short of a conservatorship. Especially spouses can do this, a certain type of petition. But what happened is the court, who didn't know this gentleman from Adam, didn't know if what he was telling the court was true, didn't know anything about his wife, had to appoint me as what's called a guardian ad litem for the wife to investigate and to find out what the situation was. And I did that, and I reported back to the court, and it was as the gentleman had said, but it was an additional cost, and all in, he had to pay his own attorney, he had to pay to file a petition, he had to go to court, and then had to pay me for that report that the judge wanted. All of that could have been avoided with the power of attorney. So when you're setting up the petition to file for conservatorship, one of the things the court wants to know is there any other option? Have you tried everything else? Is there a power of attorney? Is there a trust? Will these things do the trick, or is there another reason you need the conservatorship? And so let me give you an example of when having a power of attorney may still not be enough. I was involved in a case where the gentleman had a power of attorney. He had a trust. Everything was done correctly. It was very well done estate plan. But as he lost capacity, he became paranoid, which is one possible symptom of dementia, and thought that people might be stealing from him. So he went to the bank and he took $100,000 out of his account and he put it in another account, and then promptly forgot where he had put it and forgot about the whole episode. And so then the family became very concerned because $100,000 was missing, and an investigation was done and the truth was discovered. But that is an example where the power of attorney would not have been able to stop that. So let me give you the difference between a power of attorney and a conservatorship. In a power of attorney situation, we are not giving up anything. We retain our rights and we share them with a spouse or a trusted family member or a friend and say, please help me when the time comes, when I need it. But you don't give up your rights. In a conservatorship, and the reason the court is so careful to make sure the conservatorship is necessary and that the right person is appointed, the court actually takes away the rights, the civil rights of the person who's being conserved, and vests them or gives them to the conservator. So that is a very simple way of explaining the difference between the two. So again, it's very good to have a power of attorney, but sometimes it doesn't do the trick because you're still retaining the power to go to the bank and move the money. And if that happens, you may not, and you don't remember it, the power of attorney is not doing the trick, and a conservatorship is necessary. So I'll just talk about that. I will mention that and say that much about it. But if you if you catch between the lines what I'm saying, we do everything we can with our planning to avoid the need for conservatorship. It is one of the most expensive types of court proceeding that I'm involved in. It often involves having to go to court and file accountings and ask the judge for permission to do very basic things that you otherwise wouldn't even think twice about doing, but you have to get the court's permission. So it's a hassle and it's expensive and time consuming. And so we do everything we can to avoid it. And if you've planned ahead and done the legal planning, often you can. In very rare cases, it doesn't work, but often you can. So this is a slide which has a little less importance nowadays because of the changes in the law. But again, whatever couple we have, whatever couple, the state the couple is in, and whatever type of couple we're looking at, we want to make sure that we do the planning ahead and make sure that the estate plan is customized to the extent possible so that whatever scenario might come in the future, that couple their concerns are addressed, their goals are met. So that's the importance of this slide. For unmarried domestic partners, if you are not registered domestic partners, you have to have, there are certain rights that just simply that come from marriage or from registered domestic partnership, which you have to really assert by having the documents in place. And so carry them with you at all times. If you are registered domestic partners, you really just need to show that registration or proof of that registration because it is treated very much like marriage under California law. But unmarried domestic partners who don't have a registered RDP, they call that, would need to have all the documents, all the legal documents with them so that it's very clear that they have the right to be the decision maker and to visit, et cetera, as though they are family. So one of the steps that you can do to take the next step and to avoid these surprises and these consequences that we've been discussing is to make affirmative steps to make a legal plan or to revisit your legal plan if you have one. Gather the documents you have, gather your financial statements if you don't have estate planning documents, and I would say bring them to an attorney. An elder law attorney is somebody who specializes in these issues. They're going to make sure that everything is covered and there's no stone left unturned and hopefully no surprises down the road. Another thing that I'll just mention about our practice is that we also practice the litigation in this area. And so that's when families come to blows and there's conflict. And oftentimes that happens because the attorney that did the planning, or if the planning was done without an attorney, things were not anticipated that ended up happening. Conflicts were not anticipated. Things were not perhaps done correctly to avoid conflict later on. So it helps to have an attorney who's at least familiar with litigation of these issues because they see where it goes wrong and they can help avoid that by planning more robustly from the beginning. You can do it yourself. There's online tools, as you're well aware. And there are, frankly, office supply stores that will give you a basic power of attorney. You can buy them in office supply stores or nowadays more often online. And again, the state statutory forms for the advanced directive and the power of attorney that we showed you with the initials that you can initial next to line N. And frankly, there's a state statutory will that you can also fill out. It's one of the least intuitive documents I've ever seen, but it is a state statutory will, and frankly, it's free. So if you can understand what it says and how to do things, then you're free to use that. And again, I would say that is better than not having anything at all. So certainly use that if you have nothing, or use that temporarily until you are able to get into an attorney to address some of the more broader issues that we might want to look at. NALA is a national association, or excuse me, National Academy of Elder Law Attorneys, NALA.org, and that's some organization that I've been a member of. And you can find attorneys, elder law attorneys, online through that organization and get referrals to somebody close by. And that's a trusted source. In fact, when somebody says, "Hey, I need an attorney in Jackson, Wyoming, can you help me out and to do a deed or something?" I often turn to the NALA directory online and help them find somebody through that. Those are trusted attorneys. I don't know so much about lawhelp.org, but if the Alzheimer's Association is recommending it, then it would be a trusted source as well. Oh, that's little bit more. Let me just go back to the original slides here, the supplemental slides. This is something going back to trust. This is a really important step when you have a trust, is making sure that you actually take the next step and get the property into the trust. There are examples throughout history, and even in Michael Jackson's estate, where not everything was put in his trust and ended up having to go to court and get probate certain assets. This happens time and time again, and it's heartbreaking when I see a beautiful trust come in, but the property is not in the trust. So, a trust attorney may build you the world's most beautiful suitcase, but if your clothes and shoes are in the closet, it's not going to do you any good. A trust can only control what's in it. And speaking about that, just since we have a little bit of time, I'll mention that one of the things we don't put in trusts are retirement accounts. So that's why having a power of attorney as well as a trust is so important, because we have retirement accounts. Many of us do. For some, it's our largest asset. And we would not put those actually in a trust, transfer them, because Uncle Sam considers that a taxable event and you would pay income tax on those assets at the time of transfer. Rather, we carefully discuss who the beneficiaries of those accounts should be. Sometimes we leave those accounts through the trust so that when you die, they become assets of the trust, but we don't preemptively put them in the trust. So that's something to keep in mind. If you have a trust and you have retirement accounts, that may answer a question of why you don't have those in the trust right now. And then the last thing I just want to say is I've never had a client come to me and say, I wish I waited longer to do this after an estate plan was done. Almost universally, I hear, I wish I'd done this a lot earlier. And for some who have that diagnosis, they wish they had done it earlier because they aren't able to do as much as they might like, because of the ability to understand complex issues and the ability to show that they have capacity to sign legal documents under the probate code. So that's why the early planning is so important. I think that's why the Alzheimer's Association and why Senior Concerns are having people like me talk, because we need to be evangelists. If it's not you, it's your friend, it's your neighbor, it's your relative who should be thinking about these things. And don't be out in the rain without an umbrella on this. So if you have questions, again, Martha's going to ask any questions that you might have typed into the presentation, and that's fine. Another way, my contact information is up there. You're welcome to contact me offline. I do a complimentary consultation for anybody that's come to this. They can speak for up to a half hour. We can answer your questions and make sure that you're squared away. So I'm happy to do that if you don't want to ask your question as part of the presentation, or if you have something that goes into greater detail. All right, so, and with that, I would say thank you. I mentioned that my wife's name is Sarah at the beginning, and the way I can remember the phone number is 805-246-SARAH. So that's why I point that out there. So that's it on the slides that we have here. I will say this, that the Alzheimer's Association has from time to time has more lengthier presentations. They go a couple hours. There's an additional set of slides that talk about how to qualify for certain public benefits and reverse mortgages. It touches on that. And so if you want that additional information, do get in touch with the Alzheimer's Association and attend one of the longer seminars that they put on having to do with this. But what we wanted to do today was, in the time we had, to focus on the legal planning and touch on those primary issues.
Wonderful. Thank you so much. If you want to stop screen sharing, so
I will stop. Sorry about that.
They can see us a little bit better. That was so helpful. And I know that in my years working with family caregivers, I unfortunately sometimes encounter them when it is too late and people don't realize it. And they'll come and say, my mom now has very advanced dementia, so I need to get power of attorney from her. And so it's a hard thing to explain that power of attorneys have to be given, right? You can't just take them from somebody.
That's right. And Martha, just on that point, I will say I get a call fairly often from a child, sometimes a spouse, but most often a child. I need to get power of attorney over mom, or I need to get power of attorney over dad. And that's a common misconception, is that you get that power of attorney confers some sort of power over the person. And that doesn't work that way. It has to go the other direction. Mom or dad has to freely give that to the agent, and they have to have the capacity to be able to do that. So, a reaction I often have is, please have them call me so that we can set a time and talk about it. But often by the time the child's making that call, it's actually become too late. And that's the unfortunate thing that you've experienced.
Absolutely. So the more that we can get this message out sooner to people, the better, because it is so important for all of us. I do have a couple of questions in the chat box. One asks, what if one of the trust's successor trustees is diagnosed with dementia?
That's a great question. Whoever asked it, thank you for bringing that up. So that's one of the reasons I said earlier on with powers of attorney, but this really applies to every legal document, why it's important to have that deep bench, that 3 or 4 people at least that you have in mind that might be able to be there for you. I have clients who are on the younger side routinely name their parents as their trustees or their agents. And I don't mind doing that, but I say to them, what do you think the natural order of things is going to be here? Is it more likely that you're going to go first or them? And for everybody, I think, absent extreme situations, we would expect that our parents would go before us. So, but it's okay to name your parents, but just make sure that you also have named your siblings or your children or your nieces and nephews or somebody in a generation younger than you, so that there's more of a chance they'll be there when the time comes. And I also understand that, as part of the question, generation is not really the only factor here. There is younger onset Alzheimer's dementia. It happens to people who are much younger than we might expect. And so even somebody that we think will be there for us might not be. And so that's why it's just purely a numbers game, and naming as many people that you trust as possible, so that when that time comes, if somebody's not up to it, that there's somebody else behind them who can step in. And I will say this too, oftentimes it's not a decision that's made right when they step in. Sometimes it's something that comes along later while they're already acting. And so a good trust and a good power of attorney is going to address how to remove a trustee if the need arises, or how we have that succession when an already acting trustee becomes ill.
And this question is a good one. What are your options? What if you have nobody that you can trust to be your successee?
Right. That's a great question, and it's a fairly common question. So if that's you, rest assured you're not the only one. We have in this county and in every county some very good, very qualified, what they call, remember the word I used before, fiduciary? That's that term that refers to somebody who, by an ethical code and by law, has to put you before their own interests. So there are, as you might expect, professional fiduciaries. And so a private professional fiduciary, we call them PPFs. There are a number in this county. There's always a need for more. So if you know anybody that's got a big heart and is good at taking care of managing finances and whatnot, there would be, it's a need, it's a growing need around the state. But private professional fiduciaries are named by you in your documents or named by a court, whenever the need arises, to step in and to manage things. Ideally, we don't have to go to court, and we go ahead and we put somebody in, and oftentimes we'll do it as just a fail safe. So maybe we name a sibling, maybe there's no children, but we name the sibling. And then if the sibling isn't available because they've predeceased or they aren't up to it when the time comes, we put the name of a private professional fiduciary in as a backup. So it's a great way to just have that extra peace of mind to know that there's somebody there who's going to be able to step in. So again, if you would like names, referrals, simply call my office and we can talk about who might be a good match for you. But there are a number of good private professionals, and they're state licensed and they're bonded and they carry insurance and they know the ropes. So they're people that you can trust to do the right thing, as opposed to just hiring somebody off of Craigslist or the phone book.
Do they typically take a set fee or a percent, or just in general, how does that work?
These are great questions. Thank you. So there are two types of professional trustees. They are the private professionals that I just mentioned, and then there are corporate trustees, the banks, financial institutions. And those, again, if you have a big enough estate, if there's enough to be protecting, maybe it makes sense to have a private trust company or a bank manage your estate. But also understand that there's not quite the one-on-one relationship that you might want. Maybe there's a number of employees who are helping and rotating through. It may not be that personal touch that you're looking for. And also banks do take a percentage. That's how they operate. So they get paid based on a percentage of your assets. And they will sell something in order to free up that money to get paid. I've seen that happen. And again, I don't hold it against them. That's how they operate. A private professional fiduciary, by contrast, gets paid on an hourly basis. They get paid for the time they spend helping you. And often, very good ones will have staff, so that the staff is doing some of the more lower skilled jobs, that maybe not balancing the books, but maybe they're running errands and helping, get groceries for somebody who needs it, that kind of thing. We don't need to pay somebody a higher rate to do that. So they are providing services, a multi-layered approach to the services they offer. And as far as what they charge, it really varies by county and by fiduciary, but I would expect to pay at a minimum for the professional fiduciary themselves, about $150 to $200 in Ventura County, and probably up to $300 in other counties, depending on the cost of living and all of that. But here I would say 175, 200, something in that range is very common. But keep in mind, that's not to go shopping, that's to do the higher level work, and they have staff that they bill at a lower rate to do other things.
Okay, so if somebody was looking for referrals, they can call your office.
Yes. Yep. And full disclosure, I represent professional fiduciaries in court as well. I help them, give them the legal advice to do their jobs. And everybody needs to have that type of advice. But we're blessed with some very good ones in this county. So I'm happy to do that.
Good. Okay, this question is a little bit long, but it makes sense. And I've definitely heard this type of scenario before. So they're asking, what are the steps for updating a trust when one spouse, so there's an elderly couple, one spouse has developed dementia with clear impairment, but doesn't have an official diagnosis. And there's concerns that one of the children might make some challenges to any decisions or changes to the trust moving forward.
Yeah. That's a tough question. Just based on what the way the question is worded, I think that you're unlikely to be able to do this on a private basis with an attorney, because if it depends on what the trust says. Some trusts say that one spouse can amend right in the trust, or that one spouse can revoke the trust. And so there may be some options, but really, in most cases, it's going to need both spouses to make changes. So what do we do in that situation? We talked a little bit about conservatorship. And one of the things you can do under conservatorship is to go in and get the court's permission to make changes to an estate plan. So there's some ways to do conservatorship that are not quite as cumbersome, because maybe the assets are all in trust, and we just need to go in and get a conservatorship of the person. And then we ask the judge to do what's called substituted judgment, put themselves in the place of the spouse who's incapacitated, and do what that spouse what the judge can determine the spouse might want to do. But as a practical matter, I will tell you that the judge is going to be very reluctant to do anything that's disinheriting one child or something like that. Most often, substituted judgment is done simply to create a trust, to set one up to avoid probate, and to leave everything evenly among the kids. So anything you want to go where you want to go beyond that and make things more, favorable to one child or another, you're going to have some very compelling evidence for the judge to convince him or her to go that route. But that's one of the ways we can handle that situation. Hopefully early planning was done, and we have a power of attorney that can allow that. But if it wasn't done, then it's something we should talk about, and we can discuss based on what the trust itself says, what the options are.
Okay, thank you.
But I will say, you know, when you have the kids, when you expect one of the kids to be upset about it, that's when you really have to be careful, because you know, the costs and the time and the heartache involved in postmortem litigation after you've passed away by your children, can just be devastating. And I mean, Dickens wrote about it, you know, where the only people who got money were the lawyers, and nothing was left in the estate. And we never want to see that happen.
Absolutely. Thank you. So someone's asking if there's a website where you can search for professional fiduciaries.
So the state, and I don't have the website at the tip of my tongue, but the state of California has where you search for professional licenses for nurses and hairdressers and any other type of profession, contractors. There you can search. So if you get the name of a professional fiduciary, you can search their name on the state website to see if there's, you know, if their license is up to date, and if there's any, you know, dings on their record and things like that. There's also an organization in California called Professional Fiduciary Association of California, PFAC. I don't know much about it other than it exists, but if you search for the Professional Fiduciary Association of California, or PFAC, and Google or another search engine, you may very well find their website, and they probably have a function to search for professional fiduciaries. So that's one way that you can look them up as well.
Good, thank you. Just one final question, and I'm not sure if this is something that you can address. They could certainly contact Senior Concerns to talk this through, but who do you contact when a person runs out of money when they're at a memory care facility?
So they're in a memory care facility, not a nursing home. Is that the question?
I believe so. That's how they wrote it out.
In Ventura County, we don't have what's called the Medi-Cal waiver program. It is in other counties. In some counties, it's being piloted still. Los Angeles has it. There is a way, and Martha, I'm sure you're up on this as well, but there's a way to obtain Medi-Cal benefits. And Medi-Cal is California's branded version of Medicaid, which is a state and federal program to pay for long-term care costs that once Medicare stops, because it's no longer a health issue, now it's long-term care, Medicaid will come in and help. But the federal program and the state program in most counties only pays for nursing home care in nursing homes that have a license with the state and have accepted this program. But in Los Angeles County, there are some memory care and assisted living facilities that are licensed differently that have Medicaid contracts through Medi-Cal. So that's one way you can handle this, but there may be other resources. And certainly what I recommend people to do is to contact Senior Concerns, contact organizations like Seniors Concerns in other counties to get that information and to learn about those resources that may be available local to them, because every county has their own way of doing things, and I wouldn't want to give them, you know, incorrect information. Does that help?
Yes, thank you. Yeah, you're welcome to contact Senior Concerns. If there's no, unfortunately, you know, there isn't financial assistance available for private memory care unless potentially the person could qualify for some type of veterans benefit. The Medicaid waiver program in Los Angeles County is a wonderful option. It unfortunately has quite a long wait list right now, which I'm being told could be upwards of 2 years. We're hoping it gets expanded and comes to Ventura County, but looking at kind of when will they run out? Is there a lower cost memory care or perhaps boarding care home where they could remain longer and move to, are some other options. So it's something that we're always happy to talk through with. I also wanted to mention that Senior Concerns offers a legal concerns program where we do have estate planning attorneys that volunteer with us and provide a free consultation here at Senior Concerns to you. So they can't necessarily do everything for you, create a trust, but they can help guide you on what would be needed and provide that initial consultation. So you can always reach out to us and schedule one of those appointments. And I just want to really thank Christopher Young for joining us today. This is such valuable information, and no matter how many times I hear it, I always pick up something new. It's so complex, and so there's always nuances to learn about. So I just want to really thank you for joining us today. Our next seminar will be on December 8th, and that one is called The 4 Pillars of the New Retirement: Health, Family, Purpose, and Finances. And you can look that up on our website, seniorconcerns.org/seminars, and that's where you can register for that seminar. And I will have this seminar's recording posted on our website, hopefully by tomorrow afternoon. So you can go back and view it again, and you'll be able to see Mr. Young's contact information as well if you need to reach out to his offices. So thank you, everybody. I see some wonderful thank yous in the chat. I think that this information was really helpful to people. So I thank you for joining us today.
Thanks, Martha.
Have a good evening, everyone.